Hello, welcome to the 37th Annual Jefferson v. Fordham debate. I'm Matthew Thompson, a professor here at the College of Law. During tonight's debate, in order to ask a question, you can click on the Q&A button on the bottom of your screen and type your question in. We may not be able to get to every question, but hopefully we'll get to a good portion of them. It's my pleasure to introduce the moderator for tonight's debate, RonNell Andersen Jones. RonNell is the Lee E. Teitelbaum Endowed Professor of Law here at the S.J. Quinney College of Law. She's also an affiliated fellow at Yale Law School's Information Society Project. A former newspaper reporter and editor, Professor Jones teaches, researches, and writes on legal issues affecting the press and on the intersection between media and the courts. She's also a widely cited national expert on reporters' privilege and news gathering rights, and a regular speaker on emerging areas of social media law. Her op-eds have been published in several major news outlets, including CNN and the New York Times. And her research has been quoted in Newsweek, the Washington Post, and the New York Times, among other national publications. Professor Jones graduated first in her law school class and clerked for the Honorable William A. Fletcher on the Ninth Circuit Court of Appeals and for Justice Sandra Day O'Connor on the United States Supreme Court. She's also an experienced moderator of the Fordham debates. Please join me in welcoming Professor Andersen Jones.
Hi, everybody, and welcome to our 37th annual Fordham debate. By tradition, each year we tap into some of the hottest contemporary public policy and legal issues debated by top scholars in the field, and this year is no exception. The issue on the table tonight could not be hotter in the run-up to one of the most complicated and contentious elections in our nation's history. We are debating an issue that is central to the way that elections are conducted, gerrymandering. In recent decades, state legislators have increasingly engaged in the practice of political gerrymandering, drawing legislative districts in order to shape election outcomes and designed to favor one political party over another. The United States Supreme Court's most recent statement on this issue is that it won't make statements on this issue. That is, that courts can't address partisan gerrymandering, which leaves the regulation of gerrymandering largely to the states. Some states have created independent commissions to draw district lines, but the legality of these commissions is also in question. The legal issues that swirl around the practice of gerrymandering are both incredibly divisive and incredibly consequential. Tonight, we are thrilled to have two of the nation's most thoughtful academic thinkers on the issue, Derek Mueller and Richard Pildes, joining us to debate what, if anything, can and should be done about partisan gerrymandering. I want to thank both of them so very much for making the time to be with us tonight. Let me introduce you more formally to these two debaters who will help us tussle with these tensions this evening. And then I'll give you all a sense of the format before we dive in. Professor Derek Mueller is a professor of law at the University of Iowa Law School, having just joined that law school a couple of months ago. He's an author of numerous articles on election law issues, including Non-Judicial Solutions to Partisan Gerrymandering, which was published last year in Howard Law Journal. Professor Mueller graduated from the University of Notre Dame Law School, worked as a judicial clerk on the United States Court of Appeals for the Eighth Circuit, and practiced at Kirtland and Ellis. Before joining the University of Iowa, Professor Mueller was professor at Pepperdine Law School and was a visiting professor at Penn State and Notre Dame Law Schools. He's taught courses in election law, federal courts, civil procedure, administrative law, and evidence. Welcome, Professor Mueller.
Thanks for having me.
Richard Pildes is the Sudler Family Professor of Constitutional Law at New York University School of Law. He is one of the nation's leading scholars of constitutional law with dozens of articles, and his case book, The Law of Democracy, really helped create a field of study that explores the legal and policy issues concerning the structure of democratic elections and institutions, including, importantly for our purposes tonight, the design of election districts. A former law clerk to Justice Thurgood Marshall, he's been elected into the American Academy of Arts and Sciences and the American Law Institute, and has been recognized as a Guggenheim Fellow and a Carnegie Scholar. Professor Pildes has successfully argued voting rights and election law cases before the United States Supreme Court and the Courts of Appeals, and is a well-known public commentator, writing frequently for the New York Times and the Washington Post. Welcome, Professor Pildes.
Very glad to be here. Thank you very much for that.
Okay, everybody, our format for tonight will be to address in turn 5 key questions related to gerrymandering. The first debater will have a maximum of 5 minutes to articulate his position on that particular sub-issue. And then the second will have up to 5 minutes to make a counter argument. We'll alternate the starting positions so that each debater has opportunities to speak in the affirmative and to make counter positions. Our 35 years of Fordham debates have been focused on creating community dialogue, conversation, and learning. And in this spirit, we don't score the debate or declare a winner. And further in this spirit, we make sure that we reserve some time after the debate for taking audience questions, which we will do through the Q&A function as Professor Toxin described. So with that, let's dive in. Professor Pildes, the first question is for you to answer and for Professor Muller to counter. And the question is one on which folks' assessment of the factual dynamic is somewhat divided. It is this: has gerrymandering gotten worse over the last few decades?
So the short answer to that question is yes, but let me begin by thanking the organizers of this event, Professor Toxin in particular, for inviting me. I always accept invitations to come back to Utah. It's beautiful any time of the year. I'm thrilled to be here. You can see the fall is gorgeous. And I also want to mention that I actually worked at the University of Utah many years ago and lived in Salt Lake City when I was an undergraduate studying chemistry, if you can believe that or not. And I spent a summer in the chemistry labs at the University of Utah. So I'm very glad to be back here. And now, with respect to your question, yes, partisan gerrymandering has gotten worse in the last decade and will be much worse in the coming decade if we don't take this power out of the hands of the most self-interested actors, the state legislatures. The reasons it has gotten worse are several. First of all, at the national level, we have been living through a period where the partisan balance of each part of our national government, House, Senate, and the White House, has been closer and more likely to flip from year to year, from election to election, than at any time since the late 19th century. And what that means is, in the fight for partisan control of the House, there is much more powerful incentives to try to squeeze out every additional district in a state for a party. That's one factor. Secondly, because we have become so much more polarized, voters no longer split tickets nearly as much between the parties. Voting patterns are much more predictable. Gerrymanders that are put into effect at the beginning of a decade are much more likely to be enduring, as they have been throughout the decade of the 2010 round of redistricting, as we kind of fade out of that round and start to enter the next one. And so it's much easier for legislatures to be able to lock up control if a unified political system exists in a state where one party controls the process fully, to lock that control up and basically make the legislature or the congressional districting system fairly impervious to changes in voter preferences over the course of that decade. And we saw this very dramatically in the 2018 elections. Third, redistrictors are able to get, just like the campaigns, far more detailed and sophisticated information about individual voters. They no longer have to rely on more aggregate data about how a precinct votes. But as you may have heard, there are these individual voter files which can combine all sorts of information about individuals, their purchases of magazines, whether they go to religious institutions regularly to worship or not, whether they own guns or not. And so the ability to target gerrymandering in much more precise ways, to have it be stable and enduring throughout the decade, the incentives to do it in a highly polarized environment are very, very powerful. And then on top of that, and I'll stop with this point, in the 2010 round of redistricting, we had more state legislatures that were under the unified control of one party, along with the governor's office, in more states than we have had in previous rounds of redistricting. And so if you think it might be a wash at the level of Congress, if some states are democratically gerrymandered and some are Republican gerrymanders, that also was less the case in the 2010 round of redistricting. So I think partisan gerrymandering is always bad, but I think the power to do it effectively and in an enduring way over the course of a decade, regardless of how much voter preferences change, and to make legislatures unresponsive to changes in voter preferences has become much more powerful.
Thank you. Professor Mueller, your response.
Well, thank you so much. Once again, I want to thank Professor Toxin for the invitation, for Professor Pildes for being here to debate this topic. As we enter this sort of wrapping up the United States Census, as we look at the 2021 opportunity to draw districts, this is an important topic. And I'm not going to come out as sort of a Michael Douglas figure and argue gerrymandering, for lack of a better word, is good. Okay. What I will, however, argue is that I think there are perhaps a few themes that will emerge, hopefully, in some of these conversations. The first is I think some partisanship is going to be inevitable, and that it isn't maybe as necessarily overwhelmingly bad. The magnitude of the harm might be overstated. Second, sometimes the solutions might actually be worse than the disease, right? That it might be worse than partisan gerrymandering. And third, that maybe we'll be unable to sort of cabin the discretion of those who are engaged in redistricting in the future, in which case leaving it to the political process is a good thing. I look forward to some agreement and some disagreement with Professor Pildes on these topics, though. Let me start thinking about whether or not gerrymandering is worse now. So I think by some measures, right, we can think about entrenchment, or we can think about how, we can think about some of the political science measures that are being used to examine what percentage of the vote is occurring on a statewide basis and how that translates into seats in the legislature. And by some measures, I think it's fair to say that partisan gerrymandering may well be worse than at any point in recent American history. But I want to emphasize that there are some alternative factors that are occurring within the United States. They're sort of heightening the effects of the partisan gerrymandering. And I'll mention four of them and wrap up with sort of one suggestion that maybe it's not nearly as significant as we think. The first is that much of the partisan gerrymandering that arose because of a specific event. That was the 2010 presidential election, or 2010 midterm elections, right? Presidents usually lose, and they lose badly in their midterm elections. And the out of control party is the one that starts gaining control in state legislative chambers. Republicans gained significant control in a number of legislative chambers in 2010. And usually you don't see that in years like 2000 or 1980 because there's a presidential election, lots of turnout. Instead, the backlash happens in those off-cycle years. So one of the reasons that there was sort of this opportunity for partisan gerrymandering that occurred because there was a wave that occurred at this sort of moment in time. So it seems it's unclear what the makeup of state legislatures is going to look like in 2020 as they redistrict in 2021. There's some hesitation about how bad it will be going forward. The second is that we are increasingly segregating ourselves by political party. Democrats are increasingly living closer to Democrats. Republicans are increasingly living closer to Republicans. And through sort of natural geographic decisions about how you engage in redistricting, even if you have compact districts, you're inevitably going to see increased sort of polarization in the districts that are occurring and increased sort of entrenchment in the districts, even with sort of neutral maps. A third concern is to think that we're sort of starting to see some partisan hegemony at the state level and national level. It's hard to believe that very long ago you could think of entities like Blue Dog Democrats or Rockefeller Republicans, right? That is, in the past, while we might have looked at partisan gerrymandering maybe as a concern, there was more crossover voting that was happening between Republicans and Democrats within legislative chambers. And today, one of the things that's exacerbating that sort of partisan divide in the state legislatures is arising principally because so much of the party activity is really sort of this monolith that's happening within the Democratic Party and a monolith within the Republican Party. There's very little crossover voting that's happening at the state legislative chamber, which is its own sort of persistent concern. Fourth, there's this concern that's arisen in a lot of jurisdictions about hardball politics, or that turnabout is fair play. And so increasingly, as we sort of see the sort of monoliths of the parties, we see increasing entrenchment in certain jurisdictions. So we can draw take a state like North Carolina, where Democrats were in control for about 100 years. And as Republicans take control, they start to act vindictively and sort of with the shoe on the other foot back against Democratic policies. And there's this entrenchment concern that arises. And then finally, I have a little hesitation thinking about the entrenchment. I think Professor Pildes is right. We can look at the 2018 election, think about a blue wave, if you will, of Democratic victories, and maybe they weren't necessarily as broad as they could have been if there hadn't been partisan gerrymandering. But I look at a place like Orange County in California, one of those reliably Republican areas, and it's simply a change in preferences of the voters. Voters who might otherwise have been a monolith of Republicans have switched and become much more Democratic in their preferences. And so there are natural occurrences and changes happening within the parties, fluidity within the last decade, that maybe makes this sort of partisan entrenchment a little less of a concern.
Thanks for that. We'll turn to our second question, our second point for debate, and we'll start with you this time, Professor Mueller. Is moving redistricting to an independent or bipartisan redistricting commission important to prevent partisan gerrymandering?
Yeah, so I think when we think about independent commissions or bipartisan commissions, this was an ancient problem, if you will, ancient, at least if we think about going back to the 18th century. At the founding, there were concerns of how we're going to have these districts that do lock up. We think about rotten boroughs in Great Britain. We think at the very founding about deep concerns about drawing these districts. When we think about the word gerrymander itself, it goes back to a practice that Elbridge Gerry, the governor of Massachusetts, did. And Gerry was one of the signers of the Declaration of Independence. So this is not a novel problem in the United States. And so some of my hesitation, maybe it's a little bit more Burkean in nature, to have humility in thinking about moving forward and wondering whether or not the solutions are necessarily going to be the kinds of things we want. When we think about a lot of decisions that are quintessentially political in nature, we leave them to the legislature. Legislatures, in fact, are given the power to determine the elections, qualifications, and returns of their own members. That's actually a pretty remarkable proposition, right? We actually don't want courts or some outside entity figuring out who makes up the legislature. And the thought was the legislature as a body was in the best position to determine its own membership. And similarly, I think a lot of political judgments are best made within the legislature. The legislative process is subject to public scrutiny. It's subject to outrage, to constitutional rights to petition. It's subject to political pressures. Now, maybe those political pressures are more difficult if they've entrenched themselves for the next decade and make it difficult to win. But there are existing checks that sometimes do exist within the legislative process. When some states have thought about partisan gerrymandering as a concern, they've moved towards supermajority requirements, or they require the governor to sign off on a legislative map. And if you remember, the governor's office is not subject to gerrymandering. The governor is a statewide office subject to a popular election. So there are some existing checks. And while self-dealing is a concern, I think there's also a sort of separate concern thinking about a state legislature drawing districts for Congress. And there is a little bit of a notion, I think, that comes out of the United States Constitution, and this was something from Rucho versus Common Cause. The Constitution commits to the state legislature, as a legislature, the power to primarily come up with redistricting efforts. And there have been efforts in other states to come up with independent commissions to sort of allocate that power somewhere else. And the Supreme Court, in a case called Arizona State Legislature versus Arizona Independent Redistricting Commission, said that's acceptable. But I think it's also worth reflecting that, at the founding, despite these concerns, the express commitment was to put this quintessentially political judgment into the political branch. And when we elect those members of the state legislature, as the people of the United States did in 2010, there is a commitment that they are going to engage in redistricting. And when they do engage in that redistricting, there's a sense of trust that they're the ones who are going to draw it. Now, maybe we don't like what they did, or maybe they're not going to be subject to that pressure. And if they get too greedy, sometimes we can actually sort of speed the losses ahead. And we saw a little bit of that happening in Virginia, subject to some additional racial gerrymandering concerns that arose in the state. So I think that while we can consider independent redistricting commissions, bipartisan redistricting commissions, and I hope we'll have a chance to talk more about them, I think there's also something valuable to be said about allowing the legislature to make those quintessentially political judgments. And it's a commitment, a longstanding commitment that has been given to them.
Thank you. Professor Pildes, your view on independent and bipartisan commissions and the necessity of moving to those.
Yes, so thanks to Derek for those very interesting comments to set this issue up. So just to give you a comparative perspective on that question at the outset, we are the only democracy that uses election districts to elect members to the legislature that puts the power to draw those districts in the hand of the existing legislatures, the people who, in my view, are the most self-interested actors in this process. No other democracy thinks this is a sensible way to design election districts or to redesign them when they need to be redesigned to reflect population changes that have taken place. Now, I don't want to throw a lot of numbers at people, but to make this a little bit concrete, just to give you one example of what we're talking about here in the 2010 decade, in a state like Wisconsin, where one party, the Republican Party, had unified control of the districting process at the start of the decade, the Democrats in Wisconsin have won throughout this decade between 48 and 53% of the vote in elections for that legislature. Basically 50-50. And yet, throughout the decade, Republicans have held 2/3 of the seats in the Wisconsin Assembly. And in 2018, where there was this blue wave in voting, and Democrats received more than 200,000 greater votes statewide than the Republicans, none of this changed. The legislature in Wisconsin is locked into this structure because it was set up at the start of the decade. Now, in my view, that's not only non-democratic, it's dangerous in a democracy when you have a situation in which the political process cannot be meaningfully responsive to the preferences of voters over time. And I think it's not convincing to me to argue that the voters can change this because the whole problem of gerrymandering is that if one party has control, they're able to make these districts highly insulated from changes in voter preferences. In fact, with the sophisticated tools that are now used to do this, the consultants will tell the legislature, okay, if you get 55% of the vote, you'll get this number of seats. And if you get as low as 42% of the vote, we can work it so you'll still get that number of seats. I think it's inherently sort of pathological to put this process in the hands of people who are trying to protect themselves from political competition, trying to lock their partisan preferences into the structure of state government. And the whole reason we defer to the democratic outcomes of political processes is because, hopefully, those processes are structured in a way that makes them legitimate, fair, open to competition, open to changing voter preferences. But we can't, I disagree with Derek, we can't say, well, this is the kind of power the legislature ought to have because it involves politics. We don't allow legislatures to manipulate who can vote in massive ways. I mean, obviously, we have some disputes about that over particular issues, but we wouldn't think it's appropriate for legislatures to have carte blanche in deciding who can participate in elections. We have constitutional doctrines that constrain that. Derek mentioned that the Constitution does give state legislatures the power to draw these districts. But that power has been taken away in other areas by constitutional doctrine. Most prominently, of course, the Supreme Court held that districts could not be malapportioned. They had to have roughly equal numbers of people in them. Before that constitutional doctrine was established, we had massive disparities in the number of people in one district compared to an adjoining district, which diminished the political power of the people in the district that might have 900,000 voters compared to a district that would have 100,000 people. So I think it could hardly be worse. And I think all other democracies agree it could hardly be worse to put this kind of power in the hands of legislatures. So I do favor taking this power out of the hands of legislatures and putting it in the hands of commissions And there are different types of commissions, and we can discuss which seem to perform better than others. One type is this bipartisan commission, which sort of locks in a requirement of bipartisan consensus before a plan can be adopted. And I think there's actually a lot to be said for that. What this does is it forces a kind of bargaining process between the two sides. They have to negotiate, they have to try to compromise. Of course, political considerations still play a role, but if you have to have bipartisan support for a plan, that puts significant constraints on the manipulation of these districts in these undemocratic ways, in my view. There are also independent commissions, and that's become a little bit more common of a model in the last decade. With independent commissions, they're called citizens commissions in some states, like in California. The idea is to get people who are not affiliated with the political parties, are not office holders, and have them design the system subject to various kinds of criteria that they must meet, various standards, and the like. I don't think that there's a perfect solution to this problem. I don't think I don't want to sort of endorse a fantasy that there's some ideal system that won't still have room for political debate about how we should do this and what the value should be. I just think the last people who should be in control of this process are the people whose seats are at stake or whose partisan allies have their seats at stake. So I think absolutely we need to take this out of the hands of existing legislatures. There has been movement in that direction in the United States. There are some measures on the ballot this year to continue that movement. I was glad to see that Utah adopted, I believe it's Proposition 4 in the 2018 election. That's a different model. That's what we call an advisory commission in the redistricting process without final authority to draw the lines. So there are a lot of different models out there, but I think we could hardly do worse than what we've experienced with state legislatures having a monopoly on this power.
Thank you. Let's burrow more deeply into that question of the possibility of an independent commission. With this question, and we'll have you, Professor Pildes, lead us off. Can independent commissions be sufficiently insulated from the political process?
Well, as I said, I think it's important to keep both models in mind, the bipartisan model and the independent commission model. People who are attracted to the independent commission model often think it's a sort of a purer form because you don't have political actors or legislatures, involved in the process. But there are inevitable political issues that are involved in redistricting. And as I say, I do see some value in these bipartisan commission structures that some states use. Now, they often require both sides to agree on a tiebreaker or have a state Supreme Court appoint the sort of odd member to the commission so they can actually make decisions. The independent commissions, they depend very heavily on the selection process. It certainly takes a certain amount of knowledge about the process, understanding of the issues and the trade-offs and the like. But I think the question is relative independence rather than perfect independence. And I think we can get lost if we think that what we're talking about is a perfectly independent entity. The question is, are they relatively more independent than the state legislatures? And I think they are, they have been, they can be. There are better designs and worse designs. There's also the question of, how tightly we constrain these commissions by the criteria or the standards that they are required to apply once these commissions are created. And so that also can impose a constraint on how these commissions, whether they're bipartisan or independent, operate. So I think, there are examples of, there's a dispute, which I assume Derek may talk about, involving the Arizona Independent Redistricting Commission, which became the subject of a lot of partisan conflict in Arizona. Not the first decade that commission was in effect, which was in the 2000s, but in the most recent round. There are reasons that commission wasn't the best designed independent commission. I don't know how much of the specifics we want to kind of get into, but these design features make a difference in how well these commissions perform. Arizona had a 5-member commission. Many of us think these commissions need to be larger than that. Arizona had only one independent actor in the commission. Many of us think it's better to have several independent actors as part of the mix in these independent commissions if they have sort of requirements of a certain number of people from one party and a certain number from the other, because the more people you have who are representing kind of independent voices, the less likely any one of those persons is to be decisive and maybe push the thing down a more partisan path, whether for intentional reasons or not. But again, the devil is in the details, as it is with most things. Design choices make a difference. But fundamentally, I do believe that either these bipartisan commissions or these more independent commissions will give us a system in which we have less of this perpetual warfare over the design of districts and less litigation if these bodies act in the ways they're designed to act than in our current system, in which, as many of you know, these districts are often tied up in litigation for years because the disappointed party, if it's a one-party state, what do you think the other party is going to do? They have no resources other than to race to state or federal court and try to see if they can force a better deal through the actions of the court. That's also not great. It's not great for the courts, and it's not great to have this dragged out. And this is also among the most poisonous things legislatures do. This is so destructive of any culture within the legislature if one party rams down the throat of the other party a plan that is really going to disadvantage them foreseeably over the course of a decade. And it's the first thing they do, one of the very first things they do after the census. And it's incredibly destructive internally, I think, to legislatures and the well-functioning of the legislatures as well.
Thanks. Professor Mueller, your response regarding the Independent Commission and its political insulation.
Sure. Yeah. So I think one of the things I definitely agree with Professor Pildes about is to think about this sort of as an experiment and these different kinds of models that we're working through, right? This is undoubtedly what's happening in the United States. And we've had a few of them in 2010. We're going to have a lot more in 2020. And I'm really eager to see the fallout of those models and what ones we think work better than others, right? But I do have, just some skepticism, and again, just sort of playing that skeptic about some of the existing models as we've had, and maybe that skepticism means that it's a cue to improve them in the future. But when we enact a constitutional amendment to it, and someone feels like it's unfair, it's going to be difficult to go back and pass another constitutional amendment because the losing party, whose ox has been gored, is going to go back and say, well, we need to improve it, and the other side might not want to improve it because they feel like they're winning. So, in some ways, sort of the theme on this point about sort of being independent from the political process is we've sort of moved some of the partisanship sort of one level beyond. It's been at the legislative level. Instead, oftentimes it's getting pushed back into a separate place. I'll talk about California at the end because maybe it's the better model, maybe it's the independent one. But I will come back, as Professor Pildes pointed out, thinking about the Arizona model. So yeah, Arizona is a 5-member commission, and you can apply to it, and the commission on appellate court appointments winnows down the field to around 50 candidates, Republicans, Democrats, independents, and the majority and minority leader in each legislative chamber picks someone. So that's going to be 2 Republicans and 2 Democrats. So it's a 2-2 commission off the bat. And then they pick a 5th commissioner. And so immediately the question is, like, everything really rides on that fifth commissioner, doesn't it? If it has to be, and it has to be someone who's not affiliated with either major party. And so, yeah, the first time in 2000 seemed to work pretty well. And then after 2010, it turns out there were a series of 3-2 votes, and the independent commissioner pretty consistently sided with the Democrats. And so this is a highly controversial process if it's a bipartisan commission, but it's functioning much more like a partisan commission. And now what we're looking at in 2021, as we're preparing to sort of staff that up, is that the Commission on Appellate Court Appointments in Arizona consists of 5 attorneys and 10 non-attorneys. And there can only be so many Republicans, Independents, Democrats on the commission. And right now the governor has been appointing Republicans and Independents to the commission, but has not been appointing Democrats to the commission. And so this commission that's in charge of choosing the potential slate of people who are going to be serving as as part of members of the bipartisan commission is sort of being stacked in a different respect, at a different level and layer beyond. So structuring these becomes sort of the entire game if that's the case. So I think it's interesting to see Utah with a sort of similar model of 7 people. Again, it's advisory, so it's a little bit different, but 7 people, majority and minority leader of each chamber of the legislature choosing 4 of them, 2 more non-affiliated with someone, and the governor picking the 7th. And so in some ways, whichever the governor's selection is going to be sort of the way that the panel sort of slants. In California, however, there's aggressive work to keep this independent. And so maybe this is the kind of model we want, but it hasn't gone without a little bit of criticism. And so when we think about California, thousands of people open up for this sort of call to apply as long as you haven't contributed too much money to a political party, you haven't been a lobbyist, as long as you have registered to vote for an extended period of time, right? All these features to say you're invested, but you're not too invested in the process. And then from those, the auditor's office sort of culls it down to 120. And then another round of interviews and applications culls it down to 60. And this slate of 60 then goes, and it's like jury selection in that the California Assembly starts striking members off. And then from this 36, we take 8 by lot, and those 8 pick 6 more, and we have a 14-member commission. So it's this deeply insulated process trying to figure out how we can avoid any sort of partisanship. Now, after 2010, there was some controversy, complaints from Republicans because they said this staff was too heavily Democratic. When they hired a bunch of people to help them assist the Redistricting Commission, it was too heavily Democratic because the staff were not sort of adequately insulated from this sort of review process. I think Professor Pildes is right to think, though, that maybe independent is what we want, maybe larger is what we want, maybe requiring sort of supermajorities is what we want. But there is a way of thinking about a lot of partisan gerrymandering reforms that simply move some of the very same concerns we have the legislature have in a responsive political area, shift over to places that are much less politically responsive.
That's helpful. I want to ask a sort of burrow down to a little more of a nitty-gritty question, which is the kinds of criteria that ought to guide map making in redistricting. And we'll put the question first to you, Professor Mueller.
Sure. So one of the challenges when you have again, a quintessentially political process is we could just have sort of independent map makers, right? We can try to create an independent commission and just say, go draw the map. But one of the things we really want, right, is to give them some guidance, to give them some structure, and to provide them some criteria that they're supposed to use. And so when you take sort of a political question with, I mean, literally infinite numbers of ways of drawing the map and try to cabin that discretion, it becomes difficult, I think, to sort of narrow it down or provide sufficient guidance to these commissions. And maybe the argument is that this is a better way of approaching it. But I do think that a lot of these questions left to the independent redistricting commissions inevitably require some kinds of judgment calls. Inevitably are going to have some political questions and judgments left, no matter how much codification we put in place. So I have a few things we can think about. One is we can think about the relationship of voting age population to total population in a district. So typically what one person, one vote requires, when we think about the example Professor Pildes gave earlier about malapportioned districts, is we want equal numbers of people in districts. And so sometimes, though, we might look and say, do we want equal numbers of voters in districts too? Or do we want to try to equalize them as much as possible? Because voting power is something we care about. And the Supreme Court in a case called Evanwell versus Texas says, well, states don't have to do that. but it's certainly something that states might want to do. And again, going back to the Arizona example, Arizona's Independent Redistricting Commission drew maps where there were systematically fewer voters or as a percentage of the total population in Democratic-leaning districts and more voters in Republican-leaning districts. And so part of the question then arises about the fairness of these kinds of maps if it's the concern that the votes are being diluted in certain areas as a voting population. Another is a question about, do we want competitive districts? That's a controversial proposition, I think, because we actually still don't really have agreement on that. When California gives guidance to its map makers, says you're not supposed to sort of consider competitiveness or creating them. In Arizona, there's an express criteria saying make competitive districts if you can. And that commission went ahead and did so to the disadvantage of a Republican candidate in the congressional districts, right? And so we have to make political judgments ex ante that we put into the statute and decide what we want. And I think reasonable minds can disagree. And maybe that's okay as a federalism principle, that different states can come to different conclusions. But it's also something that's going to compel these commissions to follow particular guidance if we choose to do so. Another is to think about incumbency advantages. So we can think about bipartisan commissions, but a separate kind of gerrymandering concern is also what's sometimes known as the sweetheart gerrymander, where both parties are very happy to engage in the map drawing because, you know what, most of the people who are already in the legislature are going to continue forward. And we might think that creating competition, removing incumbents along the lines of term limits is a good thing, although political scientists say term limits are a very bad thing. But we're going to think about whether incumbency is the kind of thing that we want to put into this criteria, or if it's something that we can leave to the legislative process, leave the political process to make as a judgment. And another is to be thinking about racial minority groups and what we think about underrepresented minorities in drawing districts. One concern we have is understandably the Voting Rights Act, where Section 2 of the Voting Rights Act requires us to draw certain kinds of majority minority districts to empower certain minority groups where there's sort of racial polarization that's occurring in voting to allow groups to elect the preferred candidate of their choice. But out of the California model, there was a concern raised from the Mexican American Legal Defense Fund to say, the model that was drawn in California was not sort of sufficiently responsive to the needs of the Latino community in the state of California. Again, because that was not expressly put into the criteria the Redistricting Commission was supposed to use, as opposed to something that the political actors could have done. And understandably would have been a controversial proposition to put into the California Constitution. So all this is to say that when we think about the political judgments that happen when it comes to drawing districts, understandably, there are things that are negatives, right, when we think about extreme partisan gerrymanders. But there's also a number of other concerns that the political judgments of one era to another might not necessarily translate or might vary from the majority in the legislative chamber from one year to another. I think it becomes difficult when we're sort of distilling those claims into criteria for independent redistricting commissions.
Professor Pildes, your view on ideal map-making criteria.
Yes, and I think this is an important question that's often not paid enough attention to in these discussions. So it's not enough to just transfer this power into the hands of independent commissions or possibly bipartisan commissions. You know, as your question points out, there's still a lot of choices to be made. And the question is, what kind of guidance do we want to give those commissions through legislation, for example? And it gets into the question of, you know, what is a fair districting system? And there are two very different kind of views of that. And we have to make a choice between them, I think. One is what I call more process-oriented views about what makes a districting plan fair. And what I mean by that is the instructions to a commission would be, you have to take into account things like trying to preserve political units that already exist, towns, counties, cities, depending on what level of districting we're talking about. You have to try to keep districts that are, you know, reasonably compact, that don't go meandering all over the place to pull voters in from here and there. You may want to respect natural boundaries or natural geographic features that people treat as boundaries between different communities. And so these process-oriented concerns do not instruct the commission as to what sorts of outcomes it ought to try to reach. It tells the commission, follow these good government, if you will, or process-oriented criteria, and then a plan that emerges from that is a fair plan. Now, the alternative to that is what I call outcome-oriented views of what a fair districting plan is. And in our highly polarized political culture, in our very partisan political culture, there is a drive towards thinking a fair districting plan should be assessed in terms of the partisan outcomes it generates. So for example, if 40% of the voters, let's say 40% of the voters tend to vote Republican in state elections, about 40% of the seats in the legislature ought to be Republican, and vice versa. 40% of the voters vote Democratic, about 40% of the seats ought to be in the hands of Democrats. Now, there's considerable tension between the process-oriented understanding of fairness and the outcome-oriented understanding of fairness, partly for the reasons that Professor Mueller mentioned early on, which is we are geographically segregated by partisan voting patterns these days to a significant extent. And that means if you want to pursue fair outcomes in the way I described, measured in terms of the overall percentage of seats one party and the other gets in the legislature or is likely to get based on the voting patterns. If that's the standard of what is fair, then you will probably have to draw districts that split up towns and counties and cities that may wander around picking up voters from different areas, far-flung areas, in order to get the outcomes more in balance. And then on the other hand, if we decide to have these more process-oriented criteria, good government criteria, if you will, they may generate plans that, even though they're neutrally drawn and only follow these appropriate criteria, will turn out not to match that closely partisan voting patterns and preferences with the percentage of seats that party gets in the legislature. Now, one tendency that you sometimes see with voter initiatives to create these commissions is to kind of fudge on all of this and just throw all of these criteria at a commission with no real priority. And that's just a recipe for sort of complete discretion in the commission. You know, pay a little bit of attention to outcomes, pay a little bit of attention to good government criteria. And so you're not going to cabin discretion if you set the criteria up in that way. Now, this is a significant choice between these two approaches. Missouri, when voters there in 2018 adopted an independent commission plan, adopted the most outcome-oriented standard I've seen in any set of criteria for a districting plan. There's now political fights in Missouri about whether that voter-initiated plan is going to remain intact or not. Other states have moved more in a process-oriented direction. When we focus on outcomes, Professor Mueller also mentioned, we could decide we want all these districts to be competitive. That's the outcome we want. What does competitive mean? You know, within 5 points for either party. Competitive elections is a desirable goal. But on the other hand, if you draw every district and it's supposed to be, let's say, 53%, 47%, that means small changes, you know, could flip all of the districts, and you could end up with something that people will suddenly say, oh my gosh, that's not fair. So there's no question there are real value choices to be made here. I think that they should be made. I'm fine with them being made in the initiative process if voters are informed about what's at stake in these choices. It may be that these commissions need legislative policy choices on some of these issues. But I think the question is a very important one because it's not as if just taking the power and putting it in the hands of non-self-interested actors will solve all of these problems. Professor Mueller is certainly right. There are still major value choices to be made here, and we may disagree about those choices. So I think that brings to the surface a question about just the complexity of thinking about what is a fair districting plan. What do we consider fairness to consist of when it comes to drawing these election districts?
Excellent, thanks. Our final question for the debate portion before we turn to open to audience Q&A is a question that's of particular interest to us as a law school, right, to our law students, and that is about the role of the judiciary. We'll start with you, Professor Pildes, on this question. What should the role of the judiciary, federal or state, be in partisan gerrymandering claims?
Yes, so I do think, as I'll mention or discuss in a moment, there may be a difference with federal courts and state courts, but let me start with the federal courts. And I was part of the legal team representing Common Cause before the Supreme Court, challenging the partisan gerrymander of North Carolina's congressional districts just a couple years back. And I guess I helped contribute to the Supreme Court saying, we are not going to let the federal courts decide these issues because we lost that case 5-4. But my view on this is that courts are not the ideal place to find a solution to this problem. I do think the ultimate solution is to change the institutional forum in which this process takes place. But given that we have not done that for the most part, I was of the view that there is a role for courts to play here in putting some boundaries on the intentional partisan manipulation of election districts. I did not think, even if we won that case, that the federal courts would play a dominant role and decide exactly what an appropriate amount of partisanship was or wasn't in districting plans. I thought if the Supreme Court agreed with us, and certainly it was our position in the case, that what the courts would do is strike down what are called extreme partisan gerrymanders. And there are various ways of defining that. Now, I do think that there is a difference between the federal courts through constitutional doctrine addressing these issues and the state courts. And historically, state courts have been more willing to take on this role. And in the last decade, we've seen that in a number of additional state courts. And I do think, there's a difference, just like with every federalism issue. If the federal courts are deciding this based on the federal Constitution, then those solutions, of course, apply across the country. And there's less room for flexibility and sort of experimentation. When an individual state court strikes down a state plan as an unconstitutional under the state constitution, partisan gerrymander, whatever the doctrine is it develops doesn't, of course, bind any other state court. The state courts can look to what other state Supreme Courts have done. If they think that approach makes sense, they can adopt it. If they don't, they can adopt a different approach. So there is more room for experimentation, or another way to put it is any errors that might be made, are confined to a particular state. And I do think state courts are going to be more aggressive about taking on this role in the wake of the Supreme Court saying the federal courts cannot adjudicate these claims. As I say, I think we would be better off with courts pushing back at least against extreme gerrymanders until we get this out of the hands of legislatures and into these independent commissions or bipartisan commissions. But in the long run, that is the more stable and the healthier solution than relying on the courts. Now it will have to be the state courts to play a really, really central role in addressing this problem, which, as I say, I think is a pathology in the way our political process currently works.
Thanks. Professor Mueller, your response, your view of the proper role of the judiciary in all of this.
Sure. So yeah, let me pick up on the state court point on a couple of fronts. So one is, so for instance, Florida, when it engaged in some of its partisan gerrymandering reform efforts, decided we're going to sort of commit to the state Supreme Court as sort of a matter of our Constitution now, that the state Supreme Court can sort of step in and intervene in the event that there's an intentional partisan gerrymander. So it's sort of one decision that the people could make. And to the extent that that's sort of at the initiative process, you know, I'm interested to see more maps if they're done this way in Florida in the future. You know, the Florida judiciary has stepped in the past. It'll be an interesting experiment to continue to see. But I think there are some worrying concerns about state judges doing this. You know, and I'll take Pennsylvania and point out the two problems I saw in Pennsylvania, or maybe really three problems in Pennsylvania. So Pennsylvania had a map enacted by a Republican-controlled legislature with a Republican governor who signed off on it. And there was sort of a challenge under the state's free and fair elections clause. And that's a fairly, shall we say, capacious clause in the state constitution, right, to hold free and fair elections in the state. And it's a long-standing provision, right? Pennsylvania is an old state with this sort of provision on the books for an extended period of time. And it was brought in, the Supreme Court of Pennsylvania had recently flipped from a Republican-controlled Supreme Court to a Democratic-controlled Supreme Court. And you can also think about in the states, state judges are often elected. They are often, in some places, overtly partisanly elected with partisan affiliations. And so when it comes to the judiciary making some of these questions, I think it's an open question about whether or not sort of the partisan gerrymandering concerns have simply moved to, again, another stage of partisanship, to a judicial concern, to the judiciary that makes the decisions. Another thing that happens is they're interpreting the free and fair elections clause, and it now becomes sort of its own partisan issue within the state. What the Supreme Court did there is to look at this and say, well, we think this is a partisan gerrymander. Here's what we want you to do. Come back to us, legislature, with a compact, contiguous map that doesn't violate, or that doesn't divide up too many geographic areas in the state, like natural municipalities and things like that. Those were the criteria it gave. And as you know, as Professor Pildes pointed out in sort of the last comment, those are sort of like inputs, right? Now, the concern was sort of the outputs. This was a partisan gerrymandering that was resulting in sort of too much Republican entrenchment. And so the solution ostensibly was sort of these three sort of inputs, sort of three procedural sort of things that we care about. And then the legislature comes with a map, and the Pennsylvania Supreme Court comes back and draws a new map. And draws a new map that I think, you know, based upon political science measures, is a very fair map. It sort of provides sort of equal opportunities for Republicans and Democrats, sort of an equally divided state. And so if you're looking at measures like the seats votes ratio, it does a very good job in sort of allocating that power. That's emphatically not one of the criteria that the state Supreme Court said what was supposed to happen in a map. And there's a little bit of a concern, I think, that we are sort of subverting some of the actual desires of the court, right? That the things that the court really cares about, because it's difficult to articulate those things. Or if it articulates them, they might be contested propositions of political science, again, thinking about the outcome measures. And so sometimes there's this loss of transparency where there's ostensibly one sort of public-facing reason for doing the map, and under the surface, something else. So maybe we can look at the end of the day and say, well, I feel like it's a better map in the state of Pennsylvania, which is a legitimate conclusion that people can reach. It's compact, it's contiguous, it meets sort of fairness measures. But I do think there's a loss when it's sort of shifted away from the political process to a somewhat politicized judiciary within a somewhat capacious clause of a state constitution, and with criteria that aren't necessarily the most transparent. In my view, there are sort of different concerns that arise in those kinds of scenarios.
Okay, thank you so much, Professor Pildes and Professor Mueller, for such a thorough and helpful debate. This has been a really valuable and enlightening exchange, and we're especially grateful that you've taken the time to be here with us at this complicated moment, right, in the run-up to the election, which we know is sort of high tide, busy season for election law commentators. So it's fantastic of you to have done this. You won't hear the applause like you would at the conclusion of our first event, but everyone please join me in
Thank you.
We now do have a bit of time to give to questions from the audience, and we'll use, as we said, the Zoom Q&A feature, not the chat feature. So if you have a question that you'd like to propose for this portion of the discussion, please feel free to place it here. I'll throw some out to the debate participants for their thoughts. We might not have time to get to anything close to all of them, but I'll make sure that I'm looking over them and that I'm selecting some that seem especially relevant to our guests' expertise, and make sure especially that we're asking questions on themes that seem to be of interest to many questioners. I've got one theme that I think is definitely of interest to questioners here, which is the sort of interrelationship between the sorts of things that the two of you have been discussing and some controversies related to the census. And folks would like you to chime in on this. I'm just going to read you a set of questions here. There's an ongoing controversy about the census and the extent to which it will measure undocumented persons and hard to reach American citizens, especially perhaps in the COVID era. How does this interact with the gerrymandering effects that you've discussed? In either order, please, both of you feel free to chime in.
Do you want to start?
Sure, why not? I mean, so there's sort of two things that happen with the census. The first is the apportionment question. So there's 435 seats in the House of Representatives. And so what happens on the census is so crucial for that allocation of the members of the House of Representatives across the United States. So if there are sort of persistent undercounts of, say, non-citizens in states like California and Texas, it could result in sort of a shift of House seats, not in those locations, but elsewhere. The second stage is a little bit different, and maybe Professor Pildes has some more thoughts on this, but to the extent that we sort of have less information out of the formal census count, or we feel like that information might be less reliable in a COVID era, in a truncated timeline, whatever it might be, legislators still have opportunities to look at other, whether it's the American Community Survey or other sort of census-related tools, in helping them achieve some of the desired outcomes they might want when it comes to drawing districts. So I think the bigger concerns about the census are going to be driven at the allocation of members of apportioning the House rather than the redistricting side. But at the same time, undoubtedly, it would have some effects about the quality of the data that states have and are using when it comes to drawing districts.
Yeah, interestingly, at the level of apportionment, which is how many seats each state gets in the House, and for people who are concerned about the partisan effects, possibly from undercounts along the lines you're describing, the data, and I don't swear that I have the full command of this data, but what I have generally seen is that there will be states that are Republican states, or seem to be, we've always thought of them as Republican states, like Texas. Of course, there's been discussion this year, will Texas flip or not flip? But there are red states and blue states that would lose out in that process. And I don't think there would be a significant overall partisan effect on Congress. You could easily see significant redistributions of power within a state and in the state legislature. If there are certain areas that do have large populations and they were counted, in the last redistricting and census, but this time they're not, then that could have consequences. And as a practical matter, the way this works is that when the Census Bureau finishes the census and releases the data to the states so that they can do their redistricting, it releases that data in the most convenient form to use for the states. And so states tend to rely very heavily on the actual census information because it's the easiest information that integrates with their geographic program software and the like. So what the results in the census have very, very profound effects on this. And over the course of the decade, they may look to other sources of information. We do these rolling censuses, if you will, the American Community Survey. which surveys a small part of the population on an ongoing basis, different parts of the population. But I think areas that are significantly undercounted will lose federal resources because a lot of federal grant programs are based on population, and the population figures come from the census. So undercounting, systematic undercounting that it has large effects cascades through a lot of federal programs. And so that is a significant concern.
Thanks, that's helpful. And another question that folks seem to be particularly interested in relates to the relationship between the things that you all have been discussing and the sort of entrenched nature of our two-party system. And the question is posed is, how would our understanding of these problems change if we had a competitive three-party system?
Well, I'll start there. As political scientists and election scholars know, the reason we have a two-party system is because we use what are called first-past-the-post elections. We elect people from single-member districts. The person who gets a plurality or a majority of the vote gets the seat. And that just creates very powerful incentives for candidates and voters to support one or the other of two dominant parties. Because basically, in that system, unless your party or your candidate is likely to get into the ballpark of getting 50% of the vote or a large plurality, they know they're not going to win. In a proportional representation system, which many democracies in Europe use, if there's a Green Party, for example, and it gets 15% of the vote, it will get 15% of the seats in the parliament. So it gets real political power. In our system, a party that gets 15% of the vote gets nothing. And so what happens is strong candidates don't tend to want to run for third parties. Voters may start off supporting third parties. You'll see this in presidential elections sometimes. There's an independent candidate who looks very strong early on in the process. But as we get closer to the election and people realize that candidate doesn't have a realistic chance of winning, they start abandoning that candidate. Voters don't want to feel like they're wasting their vote. And with first past the post systems, that means you have powerful tendencies to a two-party system. And the conflicts are played out inside those two parties. That's why there are competing factions in both political parties. Now, if a third party starts looking like it's actually credibly capable of replacing one of the two major parties, then that third party will start drawing significant support. But, at the national level, we have had the Democratic and Republican Party since the 1850s. They've, of course, changed in their philosophies, their ideologies, their policies, their constituencies. But we aren't going to have meaningful third-party politics or fourth-party politics in the way some people would like to think we'll have, even though lots of voters are disaffected from both parties. And in some states, non-affiliated or independent is the dominant place people put themselves when they're asked to just declare a registration for a party. Even so, we are going to have a two-party system, and I think we need to think, unless we make radical change, and that means going to something like proportional representation. So I think we have to think about these issues realistically, in the context of what's going to be fundamentally a two-party system.
Professor Mueller, thoughts?
Yeah, to piggyback off of Professor Pildes' thoughts and to emphasize a sort of distinction about thinking about proportional representation. But what we've been talking about today, when we talk about partisan gerrymandering, really assumes that we are drawing single member districts, right? So when you have your state and your state has 99 members in the assembly, we draw 99 districts, and each one of those districts selects one person. And so you could imagine a different system where everyone shows up at the polls, you pull the lever for a party, and then, we allocate 15% of the vote, 15% of the seats. But we love single member districts in the United States. This is just, It's a hard thing to get over, right? You love having your member of Congress and your member of the Assembly. And there's something attractive about it in the sense that this is your representative. There's an attachment. There's a locality to it. There's the notion that if you have a problem with the VA or your Social Security check, or you never got your CARES Act check, you can call someone and like it's the one person I go to. And I mean, you could have a system, I suppose, where we sort of distribute those members of the legislature around the state. But for a long time, and especially as we think about racial minority representation, we like the idea of single member districts to empower those voters. And we like the idea, we've moved away from multi-member districts into the single member district. So a lot of things we're talking about, Professor Pildes is right, that we have a first past the post system, but another is this sort of system that we have where it's really driven by sort of single member districts. And again, because of that, unless you have a strong third party showing that's going to beat the other two, it's really tough to do. It's really like head to head in each of these districts one by one. And if that's the case, the third party is going to keep losing out in those where there's two dominant parties that are facing off.
Thanks to you two. Here's a question from an audience member that piggybacks on some of the comments that the two of you were making and the tension that you were seeing in the role of the judiciary. This question is, isn't it true that the more redistricting standards that you require, the more likely it is that there will be grounds to challenge the plans in court? And if that's the case, isn't it more likely that the courts, rather than any independent commission or legislature, will draw the plans? Is that a good idea, or does it further undermine the credibility of the courts in the eyes of the public? Because regardless of who draws the plan, some people, some groups are going to be unhappy with the result.
Well, someone's always going to be unhappy. Let's just start there. There's always going to be grounds. That's the one thing everybody in this debate can agree upon.
Yeah.
I mean, so if you create a statutory scheme and you say use these 6 criteria, or you can't use the 7th criteria, or you're supposed to use this first criteria first and the second criteria second, this third criteria third, there's always going to be a grounds to challenge that and to say, oh, we should have approached this differently, or they didn't give due weight to this factor, or whatever it might be. For the most part, as far as I've seen, the challenges have Professor Pildes might have some more expertise on this. Even in Arizona, where it was hotly contested, for the most part, they weren't challenging sort of the use of the criteria. The salient factors that got challenged were other things attendant to the process. They're underpopulating districts, violating the Constitution, and so on. The criteria are the criteria, and I think the commissions really do try to adhere to them, right? They don't want to go off book. And they're often non-lawyers who are staffed in these roles. And so they're heavily relying upon the advice of others to make these decisions, sort of attorneys who don't want to get reversed on appeal. So I'm not sure that necessarily giving all the criteria provides additional grounds to challenge them. It seems much more the case that people who are losers are disappointed that the criteria didn't fall their way, or that there wasn't some sort of factor used in the process.
Yeah, I think one thing that would happen if we have more commissions is that courts, when they're brought in to second guess these commissions, are likely to be more deferential and more hands-off, unless they have some reason to believe the process really kind of went awry for some reason. But as long as there's, and this is often true in law, if the process that's involved is one that the courts are prepared to kind of trust, that it's operating in good faith, they tend to be less aggressive about scrutinizing the outcome. And so I think that, and then of course, if courts are basically deferring to commissions, litigants are going to start getting the message that you're not likely to do better by spending all of the money and running to the courts. I do think that, it depends on the criteria and how precise they are. And I think if you throw a mush, or what's the word, just a hodgepodge of criteria at a commission, then you will inevitably have the litigants run into courts, because of course you could apply those criteria in almost any way. But if the standards make clear that the priorities are, A, B, C, D, and the discretion is confined to a much smaller domain, the consequences of how that discretion is exercised are not going to be as significant. The need to challenge it, therefore, the incentive to challenge it will be reduced. And so, no, I don't think that by giving fairly precise criteria to commissions, we would invite more litigation. To the contrary, a huge percentage of these plans are now litigated after every redistricting cycle. And so it's hard to imagine we could have the courts more involved than they currently are.
Briefly, so Professor Pildes noted, I think, an important point. Justice Stephen Breyer in these gerrymandering cases really came back to sort of a point that Professor Pildes raised, which is, what about step one? If you have an independent redistricting commission, we're going to presume it's okay, right? And the notion is that the judiciary wants an excuse to sort of push these questions somewhere else with the presumption that it's sort of not occurring on a partisan basis. So I think it would be very attractive for the judiciary to sort of make that decision in the event that arises. It's a great point.
Hey, it looks like we have time for just one more question to pose to the two of you. I'm going to just sort of try to consolidate because there's a theme that some folks understandably are interested in here in Utah, which is what do the two of you, top experts in this country, think about the situation in Utah? I don't know how familiar you are with all of the details of Utah's current dynamic, but lots of folks are interested in anything that you might have to say about the development of the commission in Utah, sort of passed by Utah voters, whether the legislature will observe voter preference in Utah, and whether these developments will be sufficient to counter gerrymandering issues of congressional districts here in Utah.
I mean, I'll start taking a crack at that because I have followed the Utah story, reasonably closely. I'm sure I'm not familiar with all the ins and outs of the details. And I understand the dynamics that took place before I gather the compromise legislation has now been adopted. And the simple thing to say about this, it's not really telling you anything you don't know, but we're going to have to see how the legislature responds to the commission. We're going to have to see how the commission does its work. I thought it was interesting that Utah went for the advisory commission model because that is not a common model that states which are moving towards commissions have been embracing. And I don't know actually sort of the history behind why that was the choice of the proponents of the initiative rather than commissions that actually have binding, kind of power. Now, it is the case that in a number of places that use these advisory commissions, I mean, the UK is actually what I have in mind. They have an independent boundary commission. It has to make recommendations. The parliament actually can decide to reject their recommendations or not. But for the most part, the parliament has followed the recommendations of what is an advisory, but very successful, I think, independent boundary commission in the UK. So, we'll have to see how much the legislature is willing to accept the recommendations of the commission, whether they're good recommendations or not. But I gather that at least some of the proponents, I know one of the major groups behind the initiative did come out and endorse what the legislature did here. I know the other major group in Utah, I guess it's the Alliance for Democracy, if I remember the name correctly, was more skeptical about what the legislature did here. But the proof will be in the pudding, as it always is.
Professor Mueller, do you have thoughts to share?
Yeah, so I think, it depends on the political climate of the state. And so not knowing enough about Utah's political climate, right? I mean, I think, so I live in Iowa now, and Iowa has one of these advisory commissions, and it's had one for a long time. And a lot of people chalk it up to a congenial political culture is the language sometimes used, right? And that this is something that's like kind of an acceptable. It's in the water. It's the kind of thing that's an okay thing to do. And if you look at different jurisdictions, if you're in a jurisdiction that has contentious voting rights issues, or if you have jurisdictions with intense polarization or intense regional geographic preferences, then maybe the way you draw the lines could vary significantly from kind of map to map. So it'll be an interesting experiment to see how congenial the culture is in Utah and what kinds of sort of variation the map offers from what a more partisan or legislative drawn map might be, right? It might be the case that sort of the map, it sort of does a few things a little bit more compact, maybe a little bit fairer, and the legislature says, looks good to us, right? It's sort of an open question, though. Yeah, the proof is in the pudding, I think is the way of saying it.
Excellent. Thank you so much. With that, I think we need to conclude for the evening. Many, many thanks to our debaters, Professor Richard Pildes and Professor Derek Mueller. Thank you to all of you for joining us, and we'll look forward to seeing you again at the next S.J. Quinney College of Law event. Good night.